Hello, this is John Milburn for PROP13001 Property Development, and this is week 2 of Term 1, 2018. This week we're speaking about land for development, and in relation to that topic, the chapter from your prescribed text is also Chapter 2. At 2.4.4, your authors Reed and Sims describe the process and the importance of land for development in this way. The allocation of land within a government planning authority's development plan establishes the framework for the permitted use of land and therefore directly establishes its potential value for the purposes of development. What we see from that is that the planning authority's development plan, if you like, generally planning documents, are critically important when it comes to evaluating and deciding upon and buying land for development. Of course, property development carries with it a great deal of risk, and risk appraisal is an ongoing issue throughout every stage of the development. However, the first task, essentially, is to find the appropriate land for the development. A property developer cannot afford the luxury of purchasing land for development without undertaking proper research, and that is an ongoing process. Obviously, property development caters for a huge range of activities, from small to the ultra-large. The head dictates the choice of land, not the heart. This is a business, and property development must be approached from a very business-like perspective. So the identification of an appropriate site and acquisition of the site can be a very long and unpredictable process, but of course it is clearly a huge preliminary decision in the context of developing property. So the strategy is to identify sites with a view to potential development, and the property developer may need to be flexible in terms of a specific type of development. And determining an appropriate site, the size and nature of the location, is critical. And apart from issues of, as we say, location, the property developer must consider risk profile, knowledge of the location, market forecasts now and into the future, issues of risk minimisation, and development finance. So with all of that in mind, where does one begin? What does a property developer do to begin the acquisition process? Probably the first step is to undertake some market research into supply and demand considerations. Supply in terms of the supply of land that might be suitable for development, and demand focusing on the likely end product, the demand for it, and the amount that people are willing to pay for the final product. After all, of course, if there is not a perceived demand at an appropriate price, why begin the property process development in the first place? In practicing law, I advocate that students consider the end objective that they wish to achieve and work back from that. The same principle applies in property development. Consider how to sell the completed development, then work your way back to the issue of the land to be purchased for the development. When identifying the optimal location for the geographical search, a developer will focus on the completed development and therefore the developer's perception of occupier demand, supported by reliable market research. That, according to Reed and Sims, at 2.2 of your text, is a critical factor. If you're unfamiliar with an area, a question you might ask yourself is, would you consider a joint project with a local property developer? When it comes to dealing with the land that you might use as the basis for your property development, you always need to consider what we call the highest and best use for that location. And a prudent developer will always try to seek the best location appropriate to the highest and best use for that location. It makes sense that a property developer is likely to look for land that has a direct access to, say, road networks and public transport schemes. If you were developing land, to what extent would you consider access to public transport or main roads as important? Are these factors more important when considering a residential development than an office or industrial development? To what extent is there an association between access to transport and employment opportunities for prospective buyers? And is that an important consideration for a property developer? The point of asking yourself these questions is to consider both issues of accessibility to funding for the end user and, more generally, the needs of the end user of your development. For the developer of retail property development, it is critical to plan based on information about general demographic characteristics and the size of a catchment population. Many consultants will need to provide input into that process. The property developer must consider the requirements of the property owner, that is, the landlord, and the requirements of a property occupier, that is, the tenant, when considering a retail development. The same applies conceivably to an industrial development and an office development, probably less to a residential development. But still, the requirements of an investor purchasing property and then using that to let to an occupier, a tenant, must be considered from the perspective of both. So, for example, a consultant might give valuable information about the demand for retail property, maybe things like pedestrian flows that may have a bearing on the location of retail property. A property development may conceivably only proceed if the developer receives a firm commitment from an anchor tenant. So would you base a property development on the knowledge that you have an anchor tenant and proceed on that basis, and perhaps not proceed if you failed to secure an anchor tenant? Usually these issues relate to issues to do with zoning. That's important with industrial development in particular. And a town planner should be engaged at an early stage in the investigative part of the process. This highlights the need for a property developer to be familiar with the planning process, a topic that we will explore in more detail in week 6. Real estate zoning restrictions have an immediate and important impact on industrial property development, and a property developer must consider specialised factors such as the land to building ratio when determining the appropriate property to purchase for the development. A couple of definitions. Brownfield development allows for the reuse of existing land, often in a way that's entirely different to the original use. For example, in a city, land previously used for manufacturing may be revitalised as an urban centre. But, of course, there are special challenges that apply in those circumstances, such as dealing with land that might have been contaminated. Greenfield development relates to the efficient development of previously undeveloped land in an urban setting. So who are the key players in the land acquisition process? Typically, the developer and the landowner, with or without the landowner's agent, are the key players in that land acquisition process. But a prudent property developer will engage government bodies relevant to decision making at an early stage in the process. Now, prior to making an approach to a landowner, a prudent property developer would also work with consultants to eliminate factors that would, if left undetected, become deal breakers at a later time. For example, suitable inquiries about flood levels or contamination levels at an early stage would allow a property developer to quickly discount a potential property from consideration for development. Often it is the property developer or agent or consultant or in-house member of the property developer's team who will make an approach to a potential seller to buy development land. The property developer may search the internet or physically undertake a search of properties in an area. One very good place, perhaps overlooked, as a place to start is to consider planning documents. Sometimes a property developer may become aware of potential changes to a planning scheme which provides an opportunity to purchase land at its current rather than its potential post-planning price. Through expertise, experience and local knowledge, the property developer may even be in a position to influence changes to the planning documents. Now, although the outright acquisition of a development site might be the most likely scenario for a property developer, the possibility of entering into a property development contract agreement with an asset-rich, cash-poor landowner may be beneficial to both parties. Which leads me to the point that there are alternate methods available for a property developer to purchase real estate. And as a property developer, you must always think about different ways to purchase development land. You could simply respond to publicly advertised sales, that is, properties listed on the open market. You could proactively approach landowners and do so with a view to outright purchase, or perhaps the joint venture scheme that I mentioned previously. You could even offer to project manage a site for the landowner and not take legal ownership at all. Now, if you are buying land, apart from buying it through an open listing, you could purchase through some form of tender, whether that's informal or formal, or through some sort of competitive structure, where the landowner, usually a local authority, seeks expressions of interest to develop land in a certain way. Rather than purchase outright on standard contract of 30 days, the developer could look to incorporate necessary conditions, special conditions subject to zoning, refinance and due diligence that are necessary for the property developer to purchase the property and do so safely. One other way to purchase real estate is to negotiate and enter into an option to purchase the land. That is, only if the developer exercises the option is the developer committed to the purchase. The developer could, as another alternative, purchase land at an auction, but that would typically require the developer pay 10% deposit and settle within 30 days of the auction. No matter what way the property developer acquires the property for development, the issue of zoning is critically important. Even then, buying land in an appropriate zone does not guarantee that development conditions will be acceptable to the developer. The developer must, from the outset, consider a contingency plan, and that will often require an appraisal of the risks and costs and time taken in litigation. And typically in Queensland, that litigation would be in the Planning and Environment Court, which is essentially part of the District Court. Now, in the process of purchasing land, from a perspective of zoning and incentives, a property developer may receive considerable support from a local authority. As Reed and Sims state at 2.4.4, positive participation by local authorities in making land available is not just limited to land assembly, whether by agreement or compulsion, but may include site reclamation, the provision of buildings, the provision of infrastructure or services, the relocation of tenants, and general promotion of their area as a business location. As a property developer new to the industry, would you seek out opportunities of this nature or leave that to the larger and more experienced property developers? A local authority may assist the developer by using its powers to compulsorily acquire property. That may be relevant where one landowner holds out, refuses to sell, which has the effect of compromising a substantial development, which is perceived by the council as being of advantage to its ratepayers. The local authority may in fact provide land to a developer for development purposes subject to a long leasehold interest. The same applies to a state government. That is, the developer will not buy the freehold to the site. It is a form of public-private partnership, and an advantage to the authority is that it doesn't dispose of the underlying asset, yet without financial outlay it does obtain the benefit of a developed site. For a developer, offering the security of a leasehold interest instead of fee simple is, however, likely to adversely affect its ability to obtain finance for the construction of the development. A potential financier will prefer security over freehold title than even a long lease. So what else does a property developer need to consider before acquiring property, or indeed even before making an approach to purchase property? A prudent property developer should make inquiries about the size and boundaries of the land that may and most likely will necessitate obtaining a survey. The property developer should consider easements, both beneficial and detrimental, restrictive covenants, contamination of land issues, leases and licenses, other encumbrances, and should make inquiries about prior sales information. What if we get to the stage where the property developer is ready to go to contract? Well, the first thing that they must do is ensure that they have an appropriate purchasing entity. Failure to do so in the event of changing the purchasing entity is likely to lead to the payment of double transfer, or if you like, stamp duty. Financing the acquisition is critical, construction is also critical, and lenders will often look to a pre-commitment from tenants or buyers for the funding before funding the acquisition and construction of a property development. Now, when committing to contract, the developer may attempt to condition the contract on successful change of zoning or on conditions that are appropriate for the developer, things like finance and due diligence. The developer cannot introduce these conditions if purchasing the site at auction. Alternatively, the property developer may, as I mentioned before, seek an interest by way of option, and that requires the payment of some forfeitable amount for the benefit of being able to call upon the seller to sell the property to the developer at a predetermined price. Another variation to that theme is to enter into a preemptive right agreement, which is essentially a right of first refusal, but not an option. The developer could negotiate with the landowner to enter into a long-term contract with a special condition which would allow the developer to construct the property development on the site and acquire the freehold title contemporaneously with the sale of the developed site. In other words, it is only when the developer is paid that the developer will purchase the freehold, and the transfer from the original landowner will go to the ultimate buyer either by direction or through two transfers. Now, the risk for the developer in that scenario is that the developer is developing property owned by the original landowner. That will have an impact on its ability to fund the project, given that it cannot offer a financier mortgage security over the property, but it does help the cash flow for the developer in that they don't buy the property, or pay for it rather, until they've secured a sale. That would typically only apply in relation to small-scale developments, or likely developments where the builder builds a single structure on the property, such as a house. It might apply for display home type purposes. What we have seen is that in relation to one property, there are different ways to structure transactions, and there are multiple legal interests that people might have in a single property. For example, the state government may own freehold land. The state government may offer a major developer an opportunity to construct a major retail site, let's say in an inner city location, in exchange for a long-term, say 99-year lease. So then the developer has a legal interest in the property as well as the state government. The state government may have given or received easements in relation to that property, and the people who benefit from or are burdened by those easements now have a legal interest in the property as well. The developer, having developed the site or attempting to develop the site, may have granted a financier a mortgage over the long-term lease. So now the financier has a legal interest in the property as well. And the developer may have gone on to sublease the completed product to a number of, say, retail tenants, and they also have a legal interest in the property, and there may be many of them if it's a major retail site in a city. Now, those retail tenants may have in turn mortgaged their interest in the property, that is the sublease, and their financiers will also have a legal interest in the property. So you can see that for a single property, many people may have a legal interest. The legal interest varies slightly between the nature of the interest that is held. Freehold estates, for example, are typically held, but they could be fee tail or life estates. Leasehold interest can be fixed term, periodic tenancy at will, or tenancy by sufferance. Now, mortgagees, licensees, and people who have an interest in an easement, as well as people with an interest in a restrictive covenant, do not have an estate as such, but they have some other type of interest in land. Because there are so many people that might have an interest in land, because there are so many things that might legally affect the quality of the land, it is important that a property developer consult a lawyer to consider advice, and in that regard, there are a number of standard searches that a lawyer will undertake. There are a number of environmental searches that the lawyer might undertake. It's important that these are done before the contract is signed, or at least catered for by way of a get-out clause or compensation clause in the contract itself. In your notes, you'll see that I've made mention of a number of different types of specialist searches that may not be immediately apparent even to an experienced lawyer. So in Queensland, for example, it's possible to undertake a search of the Environmental Management Register or Contaminated Land Register. Now, that search does not provide all information under the Environmental Protection Act 1994 that could give rise potentially to statutory rights to terminate, but it's a good start. Have a look at Section 421 of the EPA, which provides that termination or compensation under a contract is available if the seller fails to disclose notifiable activity or other circumstances that may lead to a classification of the site as contaminated. Also, look at Section 401 of the EPA, which deals with a site management plan. A site management plan is a plan used to manage land, and the particulars are recorded in the Environmental Management Register because the land is contaminated, and it provides for the management of hazardous contamination of that land. A property developer who fails to undertake these sorts of searches may be adversely affected down the track. It's always a good idea to obtain a town planning certificate that will show information about the town planning area or zone in which the property is located. It will also provide a statement about the conditions that might apply to the occupier of the property. So even though conditions may have been imposed originally on a predecessor in your title, as the current owner of the property, you are very likely still to be subject to those conditions, and you therefore must be aware of those conditions before you commit to the purchase. A town planning certificate, either limited or full, will provide the information that you need, but it may be that you need a full town planning certificate which contains the information in the limited certificate and a standard certificate, but goes on further to provide much more detail. Also, consider administrative advices, which deal with issues to do with heritage listings, coastal protection notices for vegetation, or clearing orders. And there are a number of other things that may need inquiry, and you may not be able to make specific searches. For example, there may be entitlement to access for extraction rights under the Greenhouse Gas Storage Act. And finally, think about the infrastructure projects that are undertaken by the state government under the State Development and Public Works Organisation Act. They may affect the property, and you need to cater for all these special circumstances with some form of special condition in the contract, or perhaps rely on a more general due diligence clause. Either or both of those may provide great assistance to you as a property developer in acquiring property. Ultimately, you need to receive and carefully consider the advice of consultants such as lawyers, valuers, town planners when it comes to acquiring property used for development purposes. Thank you.